So by participating in the support group calls, you are acknowledging you understand there are no mental health providers or attorneys on this call, and that nothing said here is any way to be interpreted as mental health counseling or legal advice. Welcome everyone to ISNAF's July 2024 professional speak presentation with Catherine MacWillie. And the topic is on parallel parenting, a very important topic because parenting obviously is very challenging when you're dealing with these types of cases. First, I'd just like to say I'm honored and grateful to have Catherine. She's been involved with ISNAF for many, many years now, since 2010. If you go to our YouTube channel, she has done multiple presentations, has always been so generous to provide her knowledge and information complimentary. Anytime we've had conferences, colloquiums, meetings, annually we have professionals speak, and she has a multitude of different topics that she's presented on. So I invite you to visit our YouTube channel, which is complimentary, and you can see professionals that have presented live for conferences as well as on our Zoom meetings, and every meeting, including this one, will be eventually edited and posted onto our YouTube channel, so you can go back and get information, stop it, and watch it and view it at your pace. So I'm very grateful to have Catherine once again, and I'm so grateful to know her. So, with 41 years of experience in family law, Catherine MacWillie, custody consultant and divorce coach, brings extensive knowledge, experience, and profound understanding on the complexities of divorce and custody. 24 years as an LAPD officer, dealing with family law, a decade-long research into the dynamics with family law. She identified that 25% of all crime may be related to divorce and custody. She specializes in high conflict cases, false allegations of child abuse, domestic violence, and restraining orders, including abduction, threat assessments, and safety plans. So with that, Catherine will be presenting this evening on the topic of parallel parenting. So Catherine, the floor is yours. Let me know when you're ready for questions.
And Cindy, thank you for the wonderful introduction and kind words. It's always been such a pleasure to be associated with ISNAF and the wonderful work that you guys do. So my topic, as Cindy said, is on why parallel parenting rather than co-parenting is the better option in parental alienation and high conflict custody cases. So I'll be covering 4 areas. 1 is the goal of parallel parenting. 2 is how does parallel parenting actually work? 3, additional examples of parallel parenting. And 4, can parents implement parallel parenting on their own? Do they need a court order? And then I'll provide my closing comments. So with that, let me get started. The definition of insanity is repeating the same action and expecting a different response. That's exactly how parents of divorce and custody caught up in high conflict cases and parental alienation define co-parenting. Absolute insanity. Co-parenting just doesn't work in these types of cases. An alarming new trend due to the failure of co-parenting is the argument in court that custody should be minimized or eliminated entirely as a form of punishment when parents fail to co-parent. Now, this argument almost always benefits the aggressive alienator in parental alienation cases. And regardless of whether it's high conflict or parental alienation, it's almost always the compliant, targeted parent who loses custody in these scenarios. The reduction or loss of custody actually acts to facilitate the failure of co-parenting as it accelerates even more egregious behavior by the aggressive alienator against the targeted parent. The reward of additional custody effectively removes any incentive for the aggressive alienator to co-parent. Why should they? They are already getting everything they wanted and more by not co-parenting, not cooperating, and not working in the best interests of the children. Co-parenting is not a one-size-fits-all. That doesn't work in clothing, and it certainly doesn't work in dealing with the complexities of family law. In fact, if families could co-parent, they would likely still be married. And just to be clear, this is absolutely not about loving the children enough to get along. It's an often repeated phrase from the bench by judicial officers, other divorce professionals, and in articles in family law. Targeted parents, therefore, need an alternative to co-parenting if they're going to survive, not only as a parent to have a relationship with their children, but to have any sort of relationship after the divorce. Which is why I tell parents all the time, stop trying to co-parent. Parallel parenting is simply the better alternative in nearly all cases, from amicable to high conflict and parental alienation cases. Let me be clear. I am not saying there is no place for co-parenting, just that it is not appropriate in all cases or all the time. Even in the best of cases, parents will stumble. When that happens, parents can utilize parallel parenting to get back on track. For example, parents who experience an amicable divorce will usually find their own way back most of the time to co-parenting situation, falling back on the court order only when they must. Not true when dealing with high conflict and parental alienation cases. Even with court orders, these cases rarely turn out well. So what is the goal of parallel parenting? To ensure that both parents play an active role in their children's lives while removing sources of conflict by minimizing communication and contact between the parents. This allows parents to disengage while at the same time allowing them the ability to make different decisions from each other during their parenting time, which was often the goal of getting a divorce in the first place in most instances. The cycle of constant crisis created by co-parenting that has held parents hostage is now removed or minimized utilizing parallel parenting, changing the dynamics between the parents. Dropping co-parenting that does not work for these cases for a program like parallel parenting that does work. This allows parents to move forward under a new structure, bringing peace to the family for everyone involved, children and parents alike, instead of World War III. With practice, parents learn to communicate in a far more direct manner, less emotionally, reducing anxiety and frustration. With each improvement, parents take steps to a more stable and peaceful relationship and conflict after conflict is minimized, reduced, or eliminated entirely. Now, of course, we know in parental alienation cases, we're not going to remove it entirely, but we can at least move it, the needle, to something more stable. With time, some parents may return to co-parenting scenario, going back and forth between the two parenting techniques as necessary. Unlike so many other issues in family law, parallel parenting doesn't have to be the focus of costly legal battle. That's because parents can implement parallel parenting on their own, no matter where they are in the process at any time. Neither a court order nor a parenting plan is required to implement parallel parenting, which is the real benefit. Most importantly, parallel parenting eliminates the ability of a parent or other divorce professional to argue that a parent should not lose custody simply because they are unable to co-parent with the other parent, which is usually due to the actions of the alienator anyway, and not the more compliant targeted parent. So, how is parallel parenting described? Think of parallel parenting as a form of custody When a parent has custody, they make all the decisions for the children exclusively as if they were the only parent involved. When the parent goes to the other parent, their authority to make decisions for them is transferred to the other parent and then back again when the children return, and so on. How does parallel parenting actually work? Well, instead of reaching out to the other parent regarding the issue, which a parent would do in co-parenting, in parallel parenting, a parent would develop their own relationship with all the individuals involved in their children's lives: teachers, doctors, coaches, counselors. Using homework as an example, each parent would contact the teacher directly to deal with the homework problem when the children are in their custody. Each parent effectively becomes responsible for their own solution directly with the teacher and does not involve the other parent. What parents also don't do in parallel parenting is become involved in an ugly email exchange, because we all know how those emails play out. One parent blames the other in the email, saying, "You're not doing their homework during their parenting time. Now I have to do everything. I can't do this all the time. You are supposed to help too. You are withholding the children's books, which I need during my parenting time, as they can't do their homework without it," and so on. In most cases, communications are intentional acts meant to elicit an emotional response to email and text messages, to interfere in a parent's custodial time, and provide evidence to use against the parent being harassed and frustrated, who may respond poorly. Not always, but usually. Requiring a parent to be dependent on the other for a solution is setting up every scenario for failure. It's a no-win for parents, and it's a no-win for children, which is what co-parenting asks parents to do: intentionally fail. This is not the intention of co-parenting, but it is the result nonetheless. When an email is required, parents would be specific to the situation in a businesslike manner, factual, with no accusatory statements. Let me give you an example in just a minute or two. School problems in particular can be overwhelming due to the sheer number of possible conflicts. So let's discuss how to handle some of the examples under parallel parenting. Let's start with report cards. Most school districts are set up to mail only one copy of a report card to an address, not two, which is the best scenario for divorced families. Instead of arguing with the other parent for a copy of the report card, a parent would meet with the teacher or school administrator to obtain their own copy of the report card and or other school documents from the school directly, and not the other parent. This is being addressed more effectively now, with more schools, their records, attendance, and report cards being available online. If this is not the case in a particular school district, parents would provide a copy of the court order and highlight the sections of the court order that provides the parent access to school information, report cards, attendance, etc. I recommend that a parent do this in person and not over the phone, so the school administrator can see the evidence, which they likely will require at some point anyway. The same regarding school pictures, yearbooks, school rings, field trips, etc. To ensure a parent receives the information, both parents must receive by separate notice directly from the school this information, not from the children or the other parent, preferably by the teacher or administrator in an email or another form of communication, or even just taking an extra copy and having a location for that parent to pick up when they pick up the children is another solution. In the case of yearbooks, school rings ordered and paid for by a parent, they will need to ensure that the school retains these items for them until they are able to pick them up directly from the school. It has to be clear with the school, with the teacher, that these items do not go home with the child. because the parent who paid for them may not be experiencing custody that particular time. This could be accomplished by a meeting with the teacher or teachers in advance so they do not send the items home with the children into the hands of the other parent. In these scenarios, more often, items would be kept by the parent who received them as opposed to the parent who paid for them, who will also ignore their pleas. Even if a court order requires a parent to return items to the other, the cost to retrieve these items through court once they are in the hands of the other parent would be too costly and better served by ordering another set of books, pictures, or rings. You have to be mindful of what you go to court over and what options are available to you outside of court and outside your attorney that you can problem solve. And that's where coaches like myself really come into place, or organizations like ISNAF. In the event of this scenario, a parent would maintain a list of the violation of court orders along with other issues to address at a later time, thereby dealing with several issues at once instead of on a single basis. You can still get the yearbook, and if you have to order a separate one, you would put that as a violation of the court order that you keep track separately and not your attorney. Of course, there are exceptions which a parent should discuss with their attorney or other divorce professional based on the seriousness of the issue and the number of other violations. When a parent receives an email from the teacher or other school personnel, they need to respond to it in a timely manner. Depending on the situation, a parent may need to copy the other parent in the emails to and from the school, especially if this is a serious issue such as weapons, drugs, truancy, vaping, bullying other students, and so on. The examples of something like this would be if a parent is parent on their communications. When they respond to the email, they would copy the other parent. If a parent is unsure if they should keep the communication confidential, they should contact their attorney or other divorce professional on this one item or be guided on several issues. Their attorney can also check to see if there are provisions in the order that may require a parent to communicate on a specific issue. Certainly emergencies, bullying, and so on, most court orders are going to require you to communicate with the other parent. So copy them on that communication. If a parent is still having problems, they may want to consider a meeting with the school counselor, in addition to the principal or others, to problem solve issues that the children are dealing with. Another tip, parents could keep a log of their meetings with whom and their positions, along with dates, times, and subjects discussed with the school, because it may become necessary to make that information available to the court at some point. Emergency cards are another very impactful issues. Parents may periodically want to make sure that they are listed on the emergency card in case it is replaced and their information is not listed by the other parent. Better yet, a parent should fill out their own emergency card so that it stays on file and is not replaced. Even though most court orders include phrasing to prevent the removal or failure to provide emergency contact information to the other parent, it happens all the time. So routinely go in every 3 to 4 months, maybe 5 months, to make sure that your emergency card is there and or that your contact information is on the other parent's card, because they can replace those cards as well. Mistakes do happen. Another reason for a parent to check periodically, make sure the information is correct and the emergency card is up to date. Another tip for dealing with parallel parenting, parents should ask to review their children's school records periodically. Review any comments or notes in the file. This could be very important. There may be notes in that file that you're unaware of. That applies mostly to elementary level, but those records follow children as they go into middle school and high school. And you want to see what your teachers are writing about your children or about the family situation. Now, files now are digital, So, some of that may be more difficult, or it may totally be all online. You need to check with your school district to see how far along they are with digitizing all their records. And if they're not, go in there. Even if your child is in middle school, go in there and look at that handwritten file from elementary school. There may be information in there that you were never aware of, that the teacher might have been told that was untrue, and you want to correct, possibly. Okay. In a format, request for school records is usually required. Someone in the school administration office should be able to tell you who to submit your request to, including all notes from the counselor, nurse, and teacher notes, and then all notes and emails regarding the children if they're in the file or can be obtained for the school review by the parent. Take photos. Take your cell phone and take photos. The school may not necessarily provide copies to you. If a parent runs into problems at the school and is unable to correct the issues, they can send correspondence to the superintendent of the school district with a copy to the general counsel. Now, general counsel is the law firm that represents the school. So if the school's not providing you with report cards, even after you ask, if they're not sending or setting aside paperwork, if you're not getting the yearbook, and you can make a legitimate plea to the superintendent and copy the superintendent. A parent don't have to deal with the other parent. A parent would not need to copy the other parent on this correspondence. To clarify, as I said, general counsel is usually the designation for the legal department in most school districts. Follow up with some kind of an appointment may be necessary with the superintendent, but a parent should keep pushing until they're given access to all their records and all the report cards and all the documents, field trips, etc. Most divorce professionals and parents are completely unaware that many school districts now have whole departments dedicated to deal with divorce and custody issues to ensure the rights of parents are clearly understood and recognized on a variety of issues, and may be another resource to involve if unable to correct with the school administrator or the teacher. In the case of enrollment or unenrollment, a parent can go directly to the school district and eliminate court to re-enroll the child. Parents will need to provide a copy of their court order and any updated copies of orders that are applicable to the school for any meetings. Again, you can do all of this without pleading to the other parent for information. Picking up the children from school can also be problematic. If a parent wants to designate another adult to pick up the children, such as a family friend, life partner, grandparent, they will need to make sure they notify the school and identify this person will be acting on their behalf. Now, you can choose to either do this information directly with the school and not provide it to the other parent unless ordered to do so by the court. But you might also want to find out who is designated to pick up the children from the other parent. You can ask them nicely, and who have you designated? Who have you designated? Here's who I've designated, so that you're clear on who should be picking up the children. This is usually only required at the elementary level, but depending on circumstances, may be applicable to middle and senior high school, especially if a protection order and other parent is not to be at the school to pick up the children. The school needs to be advised with a copy of the protection order. If an individual will be picking up the children frequently to eliminate the need to keep calling the school to provide authorization, a parent should provide that written list. The other parent may have issues with persons other than a parent picking up the children. Instead of arguing with them, what you might want to do is, again, involve your attorney and thereby eliminate the conflict directly between your attorney and their attorney to correct the situation. Now, the school will generally follow the court order, but a parent may need to pursue this vigorously. If the parent is having difficulty with the school following the orders, the parent can ask them to contact the district office or general counsel as previously identified. Again, stop arguing with the other parent. Go directly to the school, go directly to whatever department you need to get the school to follow the orders. Now, another problem that create for many is graduation tickets for elementary, middle, and high school. In this scenario, a parent would go directly to the school to obtain their tickets and avoid all contact with the other parent. It may be necessary to go to the district offices if the parent is unable to correct at the school level. You know, at one point, I would say 30% of my work as a coach used to be just on the issue of graduation tickets, begging the other parent, please, you got 6 tickets, I'm supposed to have 2. Go into the school district first part of the year and make sure that they withhold certain tickets for you and certain tickets for the other parent. And again, don't have them send the tickets home. Each parent should be required to pick up the tickets. You eliminate that problem entirely. And it's a form of parallel parenting to the next level. Parent-teacher conferences are another area of difficulty. If the school's unaware of the issue, they can assist parents and conduct a separate parent-teacher conference from the other parent, so they are the only parent. I've seen 20% of my business used to be dealing with parent-teacher conferences. One parent saying, you booked on my time, I'm supposed to have that time, or they show up during your parent-teacher conference, or there's lots of emails going back and forth. You just contact the teacher and say you'd like to request 2 separate appointments, and could the teacher please contact the other parent and let them know you're scheduled on this date and they're scheduled on that date. And again, you're eliminating through problem solving in advance of all those phone calls. Open houses are another issue. Parents withhold the kids. There's lots of emails back and forth about, hey, I didn't get to walk around the classrooms and see the work. I didn't get time to visit with the child. You know, you have to have clear boundaries, setting up open houses and field trips and so on. If it's not specified in your court order, you know, work with ISNAF or myself or some other professional to try to keep your bill to a minimum. You also don't want to run to your attorney on every single issue, which is why I said earlier, keep a list, a separate list, and try to deal with as many items at one time, unless it's critical at that particular moment, like the graduation tickets. But by just going to the office 6 months in advance, you can send the other parent a notification. I've made arrangements to pick up my tickets at the office. You'll be getting your tickets, I'll be getting my tickets. Another area that becomes problematic for parents, it deals somewhat with parallel parenting, and it also impacts what could come up in court. And that is what to say to teachers, what to say to others. Instead of sending back emails, you told the teacher that this and this isn't true. And they send back, no, I didn't say that, or I did say that because the teacher needs to know. Basically, I suggest to parents that they send an email that just says our family's dealing with a divorce once they become aware of it. And we'd like to keep this a private matter as much as possible. And, you know, if there's any issues, go to this parent or this parent on these custody days. We'd like to work with you to problem solve it and make it as easy on our children as possible. And just, you know, if the teacher asks for a little bit more details, you say, you know, divorce can be difficult. You know, we're going to work through it. We appreciate you working with us both separately. And that way, again, you eliminate the back and forth issues between you and the other parent with involving the teacher. Regarding appointments in parallel parenting, each parent makes their own appointments, taking the children to the doctor, dental, or counseling, but only when they have custody and not during the parenting time of the other parent. The exception, of course, is if the other parent or you make an agreement in writing that you will allow them to take the appointment during your parenting time with your consent and knowledge. So that I really recommend as much as possible that you get a court order specific to this issue to eliminate children from being removed from school without your consent or knowledge of the parent during your custody time. Because as we all know, schools for the most part are not going to get involved in the middle of some of these issues, and appointments being one of them. So what you would do is with parallel parenting, you'd send the other parent, I have an appointment scheduled with the dentist on such and such date and such time at this location for a cleaning. And then after the appointment, you would send a follow-up. We went to the appointment on this date and this time with this dentist, and it was a normal cleaning, or there was 2 cavities. That's it. But you need to provide the information on what dentist and so on, so that the other parent can call if they have any questions. You don't have to open it up. If you have any questions, contact me. No, just say, if you have further questions, you can contact the dentist direct. Now, I will be providing a copy of this presentation. You just need to email me for a free copy, and I'll provide the email address, or Cindy can provide it. And it's all provided at no charge. So you won't have to necessarily try to keep up with taking notes on everything. Parents, again, should refrain from writing accusatory emails such as, the children are not brushing their teeth at your house. That is why they have cavities. The prescription isn't working because you're not administering it to them during your parenting. These are all common in co-parenting communications. Trying to force a parent to cooperate and provide information is not going to result in the other parent suddenly and magically complying and providing the information that you should have been provided in the first place. To go around this issue in parallel parenting, you would contact the doctor's office directly and ask for a copy of the children's records and any recent appointments. So this would be in the scenario in which the other parent takes them to the appointments, but you have no knowledge of the appointments, or the child says, oh, I went and saw this and this happened. You can just go ahead and contact the doctor's office directly. If you don't have that information, then you might need to go to your attorney on that particular instance. Or if you're providing the insurance, you can simply go to your insurance company and get that information and all other notes. So there's alternatives to almost all these scenarios. If not, a parent should utilize their attorney to communicate with opposing counsel for this information and go around the parent who is withholding the information. Again, if that doesn't work, the parent would keep track of these issues they need to address in a contempt motion and handle multiple issues at one time, as opposed to one issue each time they occur. But you need to keep your own list of violation of court orders, so that you can, after watching the other presentation, learn what your options are that are far more effective. Okay, that will keep your court costs down. First of all, that you keep the list, and there's a format that's provided in that other presentation. If 1 or 2 items are struck down by the court, parents would not have to wait years to go to court. 6 to 9 months seems to be the time frame that it takes to get into court right now, and even sometimes longer with all the continuances and backlogs. So really need to plan and pick carefully. Additional examples of parallel parenting. If a parent enrolls the child in an activity, it is with the understanding that the children will participate only when that parent has custody of the children. There should be no exception that the other parent will participate, whether it be sports, music, dance. I really want to emphasize that. Parents spend so much time going back and forth saying, I enrolled the children, I expect you to bring them, or you said you would bring them. No, if you enroll them, it's with the understanding that they will only occur during your parenting time unless you have a court order that specifies otherwise. If the other parent chooses to have the children participate in the activity full or part-time during their parenting time, that is their decision exclusively. Emails demanding that the children attend activities are not appropriate by either parent. This separation allows each parent to have the children participate in those activities they wish without the demands of the other parent. Parents should remember, even in intact families, children do not always attend all games, practices, or functions. Today's coaches are well aware of the various issues. In the case of a question, parents should simply speak to the coach, outline their situation on their custody time to see if the coach can work with them. Otherwise, a parent may need to seek another team or activity. Another option a parent may want to consider is to see if they can hire someone to coach to work with the children so they can stay on the team or the equivalent so that the children can continue to participate on a limited basis. Parents should not rely on the other parent for reliable information on practice and games locations or last-minute updates. Again, a good percentage of my coaching business has been about the other parent withholding information on coaches, game locations, times, and last-minute updates, as many parents even provide false information to the other parent to keep them from attending the activities. That is because a problem related to the children's activities includes false information provided on dates, times, even the wrong location provided by the other parent. Even the parent just wants to watch the children in their big game of practice during the other parent's parenting time. When the children are with the other parent, they need reliable information. So often the information provided to the other parent is false. Parents can avoid all of these scenarios by obtaining their own updates directly from the coach. Again, tell the coach, we have a difficult situation we're working through, and I just need to be on a separate email list. And if you can make sure too that there's no errors and that I'm not removed, I would really appreciate that. Again, the purpose of parallel parenting is to avoid these situations by cultivating your own contacts, receiving your own emails or notifications directly with the activity coordinator or coach. If there is an issue, contact the coach directly and not the other parent. Another tip is to urge parents to maintain their own set of uniforms and equipment at various times. Like I said, 30% of my time as a coach revolves around uniforms and coaching equipment and false information. Parents can cut out all this frustration by keeping their own set of uniforms. I know it's a little bit more expensive, but after each game, if the children are not coming home to you, you would just simply take the uniforms at the end of the game and bring them home and wash them. In the case of an emergency, what would happen then in parallel parenting? That would be the exception to parallel parenting. Most court orders are very specific regarding emergency situations. Language like immediately or within specified time period or as soon as possible. The other parent shall be notified of the emergency and or hospitalization of the children. This applies to dental and psychological emergency issues as well. Just to be clear, parallel parenting does not mean no contact. It means that contact is minimized to those issues that are necessary for the parents to discuss as outlined in the court order or an emergency. Parents tell me all the time they have been parallel parenting but didn't know there was a name for what they were doing. Then I read their emails and tell them this is not parallel parenting. So it does help to get a coach. There are coaches who specialize in parallel parenting. Again, ISNAF is great. Cindy's amazing, and so is her staff and other volunteers or myself. And to make sure that you clearly are. Now, a parent reading an article on parallel parenting is not going to magically make everything better. It's not going to happen overnight or improve communication or parenting skills with the other parent in a few days. But with practice, it will get better. In most cases, once a parent has the basics down, they will be amazed at how much better their lives and that of their children can become. Notice I say in most cases, because let's face it, in PA, no one solution works all the time in all cases. but parallel parenting comes pretty close in my experience. One parent that I worked with said they never imagined their life could be this good. They never realized how much co-parenting was actually hurting their family. Not only did this family move to a much better parenting situation with their children, but during an emergency, they avoided court entirely and huge legal fees as a result of their use of parallel parenting prior to and after the incident. Of course, it also helped that I was working in the background with a calm voice, reasoning with my client that it was possible to avoid court and remind them of all the progress that would be lost if they went to court. The client has called many times to say thank you. They said if people only knew about these options, many of them could stay out of court. This family has continued to do really well and thrive, like many families, utilizing parallel parenting, something that all parents and all families deserve after divorce. Now, I will also say that AI is becoming a really great tool. Cindy and I were discussing that even prior to the start of the presentation today. I use AI, and so are a lot of other parents. You can even try like Jasper.ai, GBT, and they also provide like a free opportunity to try out the program. It does take a little few starts and interruptions to get it down, but you can change the tone. You can tell them, I want to accomplish an email that communicates this information. And you can say, I want to remove all anger, accusatory statements. I want the tone to be professional. You can set all of that, and Jasper, you write the email that you want or have the AI write it for you, but you can continue to hit new revision until you get something that you're comfortable with. So AI could be changing a lot of things in family law going forward and reducing costs for parents, which I fully support. I'm probably one of the few divorce coaches that feels that if I could put myself out of business, then I did a good job, with my clients when they don't need me, when they can move on. So I consider more money in their pockets a benefit to my reputation. So anyway, can parents do this on their own? Absolutely. Depending on how much research a parent does and how well they apply what they have read to their specific situation, they can do this on their own. And time is of the essence, and usually it is in these cases. There are other options, especially if a parent wants to reclaim their life and their parenting time with their children as soon as possible. Use AI, try it out, see how well it works, then run it past Cindy and see how well, she feels it's accomplished. By working with someone who really knows how to implement parallel parenting, the difficult part is not, however, in parallel parenting, is not many professionals are talking about parallel parenting. Not many have experience with parallel parenting or even know it exists, making it difficult to find help. But the resources are out there. And again, AI can really speed this process up. Another is cost. If you do find a professional, it can be expensive to be coached on one. However, a few hours spread over several phone calls or several weeks can really make a difference to jumpstart the process. Helping parents to avoid as many mistakes as possible in the process is another bonus of working with a professional. Most importantly, I want parents to know they can absolutely thrive after divorce, and so can their children. Here are a few tips from Edward Kirk, PhD, who endorses parallel parenting and when possible, co-parenting. So what are the benefits of parallel parenting for children and when possible, co-parenting? A sense of security. Children who maintain a close bond with both parents are more likely to have higher self-esteem. Well, of course, we know that. But in PA cases, you can only control what you do and not the only parent. But as much as possible, minimizing the strife during emails can really make a difference. Better psychological adjustment into adulthood. Research shows that adults raised in divorced families report higher self-esteem, and fewer trust issues if they had close to equal time with both parents. Again, PA makes that difficult because of the alienator. So some of this, but this, if you can remove as much as possible, you can get closer to the bar that these goals were set at. Children grow healthy, or mentally, if they see their parents cooperate with one another. This is true even if parents are disengaged with parallel parenting, as long as they were respectful to each other. So as much as possible, you pick up the children separate of each other, you stay away from each other during different functions, and so on. Again, PA does make it more difficult. Good communication skills help to establish a life pattern of healthy relating that can carry children into their future. This includes graduations, weddings, and family events. Again, this isn't new research, but what is difficult oftentimes for the courts and judges to understand is how frustrating it is when you get email after email after email accusing you of actions you never took, never meant for it to be read that way, and is used against you in court. So this parallel parenting and these emails are critical to protect the evidence that can be used against you. Better problem-solving skills. Children and adolescents who witness parents cooperate are more likely to learn to effectively resolve problems themselves. Well, again, PA changes the dynamics on all these issues, but you can talk to your children saying, we're going to, I sent dad an email about your doctor's appointment. So, he's got all the information. I talked to I sent a text message to mom about this, so they know all about it. Your upcoming field trip, there's already been a discussion between your mom and dad about this. So you can communicate a little bit, helping your child not be fearful about field trips. Also communicate a little calendar that the children can carry so that they know who's supposed to pick them up. That will relieve some of the stress where the child just looks at their little calendar about who's going to pick them up from school. Again, good communication with the child, as well as notifying the other parent. Okay, I put a little calendar together when they're with me. If you want to put a little calendar together when they're with you, so they know who's supposed to pick them up from school. Parents no longer need to be held hostage in high conflict cases to ill-equipped parenting techniques such as co-parenting because there are alternatives. Research is leading the way in many improvements, and the court and many divorce professionals are slowly, I emphasize slowly, catching up. They're being forced to. Now, there's many support groups that are now being offered all around the country. Parents should reach out and participate at little to no cost, learn all about these options. Again, you have ISNAF. They're great. There's a lot of other great organizations. Attend and participate in as many conference calls and videos that you can. I want to leave you with this line from the Huffington Post. Marriages come and go, but divorce is for forever. And I really feel truer words were never spoken. So I'm going to go ahead, Cindy, and open it up to questions now.
So, Catherine, thank you so much, because my children are adults in their 20s, 30s, but everything you said is so apropos. And one thing I want to remind parents about is when we go to parallel parenting, we take away the power of the other party to continue to get fuel from us and get the narcissistic supply, and we empower ourselves. And is it extra work? Absolutely. It's a lot of extra work. But, it isn't that the partnership is over, and we understand the personalities we're dealing with in these types of cases. So take your power back and start being in communication and do that little bit of extra work and create those relationships for yourself and create that one-to-one, and they'll do their own. And then it also takes away the conflict of the child watching the two of you go at it in front of their teacher or at the school with the principal. And instead, they have their relationship, you have your relationship. And I do also, regarding schools and including if you have pediatricians that are one doctor, highly recommend that parents also give that party and have a particular meeting or, that you might set up and give them a copy of the parental, I'm going to say orders that you have on your case. They don't need your whole order, but they just need to see what are the parental orders, and then they know what to work with. So thank you so much, because that covered a lot, and I hope you all realize I got to parallel parenting after the School of Hard Knocks, and dealing with everything Catherine said was I was slapped around with. And then I ended up in parallel parenting with before I ever knew it was ever a thing. And so thank you for presenting that in a package, because I can't say enough about it. So with that, let's go to our questions. And if you have any other questions, please do post them. So the first question right out of the gate, which came early, was, what strategies do you suggest for parallel parenting when the 16-and-a-half-year-old child is living with the co-parent and has excluded the alienated parent from all aspects of the child's life?
Well, again, you can go to the school, and you can get their report cards, you can get their attendance, you can find out what's in the file, you can see if any IEPs, individual education programs, have been ordered or being considered. That's dealing with the school. If you're providing the insurance for the child, then you can go to your insurance company and get copies of everything: doctors, dentals, counseling. You can get all of that information. Again, what's happening is there's an alignment between the child and the alienator. So just like you're going to go around the alienator, you're going to go around your 16-year-old. So what you can do is go, if they're participating in sporting activities at the school, you can go and meet with the coach at the school and say, hey, I got to bring that court order, that because they might have been told that you don't have a right to this information. So bring a copy of your court order specific to custody, not the financials. Unfortunately, sometimes the schools will say, unless the whole court order is there, they won't accept it. That's the only problem, unfortunately, Cindy, unless you've got a parenting plan as a separate attachment. But go and meet with the coach. If you can talk to any of your son's friends, the parents of your son's friends, tell them, hey, you know what? I forgot what the game location is, or who the coach is, or, I'm sorry to say that I don't have any information on my son's sporting activities if they're at Parks and Recreation or a private sports activity. Would you, is that something you could provide me with? Now, some parents may not want to ask another parent for help. Some parents may not want to provide that information to be dragged into it. On the other hand, some parents may be very, very sympathetic to your situation. And if you just ask them in a calm manner, hey, don't have some of the information on his sports activities. Is my son playing baseball or football or hockey or any of those things with your son? And then you're just giving the information, you're just asking for the information they already have with their child. Yeah. You may need to go to 2 or 3 parents. That would be one way around it.
Yeah, and to your point there, Catherine, I can't say enough. I never recommend to parent, because Catherine, like I, do a lot of coaching around this. I never recommend to a parent. I do recommend, just like Catherine, yes, definitely inform the school. However, I never advise parents go to the school and tell them you're being alienated and the other parent is in with the child. And I say, absolutely, they're not therapists and they don't want to be in the middle of your divorce. So minimally, you want to say, we're going through a divorce. It's a little bit contentious and information's not being shared. I just want to make sure that I can get what I need to get. So please keep me and dad separately, or mom and dad, whatever, separately on the files. And what do you need from me to be able to help you make sure I can get everything? Here's a copy of the parenting plan. And to what Catherine said, I was in my case, because my divorce order was 75 pages, which had way more information than the school needed to know. So I would typically provide the parenting plan. The first page parenting plan and the signature page, that would be sufficient. It would be like maybe 3 or 4 pages. That would be it. And I've continued to, I'm still doing some other things on the financial side of things years later. But yeah, so I, for everybody there, I never recommend go in and say, well, the child's favoring the other parent and I'm being alienated and they're blocking me out, and they're not our therapists and they're not there to coach us. They're there to educate the child to the best of their ability, and they do have a legal responsibility to keep both parents informed. However, in my own case, I had my ex go in there and tell them I had a restraining order. And when I showed up for a parent-teacher conference, they said, you can't be here. I said, what? And I was so sensitive at that point, tears rolled out of my eyes, like, what? What? And they said, well, you have a restraining order. I said, what do you mean I have a restraining order? Can you please show it to me? Oh, well, your ex said, and they had no court order, nothing. And the next day I brought them the court order. But yeah, and we all know what they're capable of doing and saying and lying and convincing. And, convincing is one of their main suits. So do keep the professionals in your case informed. Do make a point to have a relationship with them and build rapport. And do make an effort to not bring them into the middle of the conflict. Just create the relationship. As I'm the other parent, wanted to introduce myself, want you to know who I am. Here's my information. What do you need from me? And I'd like to just continue to be informed. And that's a professional relationship.
Yeah, and to your point too, Cindy, is what happens is when parents are targeted by the alienator, they're so distraught that when they go and they pour out, every aspect of their broken heart and legal issues, they actually support what the alienator's saying about them. It's not what they intend to do, but if you just say, we're just in the early stages, or, it's a difficult situation until it's smoothed down. I'd appreciate it if I could have this information separately. And you don't need to tell them about court. And the less you say, the more professional and a little bit detached. And by just saying, hey, I appreciate your help. If you can just provide this information to me. And that way it doesn't fall through the cracks for, like you said, either one of us. And that's what this is really about, is helping our children through this. So, and by doing that, you actually will put yourself in a better position with the opinion by that teacher. They'll do more for you because you're not trying to convince them that been victimized and the other parent's all bad and you're all good, which is what the alienator's doing.
Right. And even if the other parent already did that, which many of us are confronted with that, even if the other parent did that, when we show up looking like the stabilized, healthy parent, now they have an opening for us and they recognize, like, that's interesting. That I just got lobbied by the other parent, that this parent, look at how nice this parent is. And they were kind and professional. And they want to know and they want to be involved. So, yeah. So this is such an important point. I can't say enough about it because we're going like beyond just parallel parenting, but
right.
We must be, as targeted parents, we must be extremely mindful about not showing up with our trauma and our drama. And we must show up regulated and do your support group meeting, do your therapy, do all of that, and take that stuff there to deal with what we're really dealing with. But when we're presenting in the community with our children, their coaches, their teachers, their doctors, we must present ourselves as very stabilized, very regulated, loving, compassionate, with dignity parents. And then you'll see that you'll start getting a lot more mileage, including in court, by the way. So let's move over to the next question. How do you suggest presenting possible activities for the child to participate in to the co-parent and offering to pay for them without it appearing that I'm trying to control the activities?
What I would do is not discuss the financial aspect of it initially. Just say, hey, two approaches. One is, hey, here's some activities that I was considering. Is there any desire or intention, or would you like to have that child, the child participate in any of these activities? And see what their feedback is without even mentioning money. And then when they come back and say, oh, I don't like any of these, or, oh, we can't afford these, then you could say, well, if they're participating, I would be willing to take up that cost if that's an issue for you. And you have to outline, here's the schedule. You can't just say, I'm thinking of tennis or swimming or dance. You have to say, here's what the schedule would look like, and how it would impact your parenting time and my parenting time. Is any of this look interesting to you or acceptable to you? And if you don't want to do it, maybe I'll just do it on my time. Offer that up too. Offer up, I will just do it then on my parenting time if none of this looks interesting to you, because I don't want to interfere in your parenting time. And you might go to the point of making that comment. Hey, if this doesn't look interesting and you've got some other plans, I understand. I'll just do it on my parenting plan.
Something that Catherine just said, in the world of communication, we have a roundtable on that. Notice how she asked the parent, does this work for you? How does that work? What do you think about? And then if it does impede on some of the time they have, you could even say, well, if I realize you work, if it works and you'd like to agree to this, then I'd be happy to provide the transportation, and I can get the backup for that. And if not, then I could do this time. What do you think about that? But notice the asking the question, because with the cluster B personalities that many of us are dealing with, power and control is everything for them. So when we defer them to that asking the question, it's very helpful to possibly get the result that you might want.
And Cindy, as you know, the alienator will say yes with no intentions to cooperate whatsoever. So you have to be prepared for that. Even if they say, yeah, that sounds great. Oh, I'm really for that. Yeah, that sounds great. I want to do that. Oh, you're willing to pay for that. Oh, that I'm all in. And then they don't take them to anything. Then you can't come back and be accusatory. Don't send any emails saying, I'm under the impression this isn't going to work for you. No problem. I'll just take them to the activity during my parenting time. So you have removed their ability to make you angry. You've removed the ability to go to court to say you're not responding appropriately when you couldn't fulfill your original commitment. And you just say, hey, I get it. It looks like this is going to be really difficult for you. I'll just do this activity during my parenting time only. And now if they try to go to court and say you're responding inappropriately, you say, no, I said I understood there something changed and they can't do it. You take away their power and you get it back to yourself. Yeah. They didn't minimize you. They didn't aggravate you. You knew from the beginning they might say yes and then never intend to follow through.
Yeah, and to what Catherine is saying there, I'm going to add something for mindfulness, because these conflicts will go on with minor children all the time. It's just part of what happens when both parties have any custodial time. The other parent will do everything to thwart your time and make everything miserable and align the child over and get to the total rejection and the splitting of the child. So one of the things I want to remind you of is that pick your battles and decide, like Catherine just said, like everything is not a major. Let's say they said, yeah, sure, you can sign them up for ballet camp over the summer and you just spent $2,000 on it, and then they don't take them, right? And you're going to like, okay, that's it, I'm going to go to court. So I want to invite you to consider the cost of court is a minimum to have a hearing, minimum of say $5,000 average. It could be more, and definitely probably not less by the time you get your pleadings and the discovery and file your paperwork, and then your attorney shows up in court. Figure you're spending $5,000. So I want to invite you to consider, before we start picking every little battle and getting into these kinds of situations, how much am I spending, and is that even worth it? So, I had a situation in my own case where getting for my younger son, that dad agreed to have the braces put on. He agreed to pay half. They put the braces on, and then 3 months later, he said, I'm not paying half. So I'm not going to pay anything. So the orthodontist stuck in the middle came to me and said, well, so you're going to be willing to pay for it all. Now, total cost for that was going to be $6,000 split 2 ways. And I actually went to the ego place and said, no, he agreed and he needs to pay, but he withdrew that he's going to pay to the orthodontist. And the orthodontist said, I'm not chasing him and your divorce situation's not my problem. So if one of you is not going to agree to pay, then I'm going to remove the equipment from his mouth. Yeah, everybody get that? So
Yep.
I talking with a family member of mine, and she so wisely said to me, are you kidding me? Just pay for it. What are you going to spend to go to court? And at that time, it would have been $3,000 or $4,000. She goes, well, that'll pay for the braces. So why would you even consider that? But I want to invite us all, like, we need to recognize, like, that would serve my son. Not going to take it out, put it in, go to court. Just pay for it, eat it, move on, and keep the, he got his teeth fixed. And, so think in that term, like, how can we avoid the conflict? It doesn't serve our children to be in the middle of that.
Well, and the reality is that in most states, there's only 2 options with the courts on contempt motions, and that is fine or jail. So how many parents in all the years I've been doing this have gone to jail? None. And how many parents pay fines? Very few. Very, very, very few. So, there needs to be an alternative to contempt, which, we can offer now. But I thank you for raising the issue of braces, because I've had more than a few clients who have done exactly the same road you went down. They went down, only they went to court. And not only did the judge say, well, you're being unreasonable, versus the other parent who simply changed their mind. And so that parent, I usually try not to identify the parent, male or female gender, ended up paying attorney costs for herself and for the other parent, and paying the cost of the braces. And I had told them up front, and they were committed to ensuring that for once the other parent was going to fulfill their requirement, and this was for the child's good. That's why it's so important to have another party that you can go to who keeps your emotions under check, so that they can explain to you, if you do this, you could be looking at $5,000, for attorney fees. And I'd say that's about right. Court will be continued 2 or 3 times. And at the end of this, not only will you not get any jail or any fines in all likelihood, but you're going to lose all your time and emotions with your child. You're going to lose your money that you could have spent with your children on vacations or necessities, because it's pretty hard to go on vacation when you're involved in parental alienation. But even a weekend getaway, all that money is just going to an attorney who can't give you that response that you need. And even in the few cases that I have gone to court on, that I thought, oh, for sure this time it's 150 violations or 140 violations with an additional 40 to 50 in the first 2 years, we should be good. And that's after they lied about false allegations of child abuse and domestic violence. And the court didn't pay any attention to what was nearly 200 violation of court orders in the first year and a half. Didn't even blink an eye. And the parent lost parenting time.
Yeah, and to what Catherine is saying is really critical and important. We might be right, and then when we get in front of the family law court, which by many family law attorneys will call it the wild, wild west, you never know what you're going to get, and they don't work exactly by the word of the law. They kind of interpret what they want, and this is many, many judges, okay? Not that every judge is that way, but majority of them are. They don't understand PA because it's counterintuitive, and they operate from intuitive. So start looking at, where can I have my power back? Where can I make the decision? And the most important part of your situation, and I can't say enough, my children are 26 and 32 now. And they were 4 and 9, and I went all through the courts and all of that. The best thing that I would say that I learned from that was keep your children out of every bit of conflict that you possibly can. Keep them out. And do what you can on your own, do what you can in the background, do what you can to resolve things. And is it going to be fair? No, it's not. It's absolutely not. But it's worth preserving our children's well-being.
I would say that for a long time, I've always used the phrase, you can go to Vegas and get better odds than family law. While there are some very, very good judges, they seem to be in a smaller group all the time. And I just recently had a case on domestic violence in which the other parent did not turn in their weapons as required to do by a temporary restraining order. By California law, that violation mandated that the courts issue a permanent restraining order apart from any of the allegations or evidence, just by the violation of withholding those weapons and not turning them in. But the judge did not issue a permanent restraining order, and in fact came down and said they did not believe the parent. But by California law, when he didn't hand in those weapons, he violated the law.
It's considered the wild, wild west. It's
I think that's almost
based on what?
Yeah, and that's almost a kind. I think it's, from a planet far, far away now, it's so unreliable now, more so than I have ever experienced before. You used to be able to at least have a good attorney and good evidence and good paperwork and good filing and stand a chance. I'm becoming more and more disenchanted. It just depends on the judge. It doesn't even sometimes depend on the evidence anymore or how good your attorney is. It's a roll of the dice.
Yeah,
it really is.
Yeah, that being said, I do recommend to those of you that are in court, and I'm guessing many of you are because you're here obviously with minor children, that you go sit in court, walk out a morning and find out if your judge is hearing cases, and go sit there and watch them for 2 hours and observe, like, how are they ruling? What are they doing? What ways are they leading? What do they seem to understand? And you can kind of hear that by them. I do that actually. I have parents who have me go to court and come up with, like, what do I see, who they are, and then how to present your case. You could do that yourself, but minimally know who you're dealing with. Okay, so we're going to move forward. So where can I find Catherine's presentation on options to working around going to court for contempt? So Catherine, you want to state?
Yeah, so I did a presentation a few months ago on, workarounds to contempt. If you will, I'll give you my email address now. Anybody who'd like to get a copy of that. It's divorce, DIVORCE, coach, COACH services, and that's plural, SERVICES @yahoo.com, and request the contempt options and format. And then if you want a copy of tonight's presentation, you can also email me at that address.
You got that? So the next question, I'm going to have your feedback on it, but I have an answer for it. And this one is you cannot get copies of a 16-year-old's medical records in California without their permission. I'm going to challenge that. And in California, this is a California situation because other states are highly different. But I'm going to invite you, this parent, to check out California Family Code 3025. Because parents in the state of California are entitled to all medical records and academic records, unless there's a court order specifically forbidding you from having them. So then let's move forward. So how can I find a parallel parenting coach? Well, you're looking at two of them. You have Catherine and you have ISNAF here. So there you go. In the United States, we have what are called IEP programs. I'm not certain what that might be categorized as in Canada. where they're special education, they have special needs, and they put the child through a battery of different tests. In the United States, there are district psychologists, school psychologists who can kind of keep an eye on a child who's emotionally confronted that we can talk to and work out. But that again starts with the administrators of the school and meeting with them. Again, I'm not sure, I don't know of a school on the planet Earth. We work with international cases, not to mention international professionals, who has a school district who will actually take on working privately with an alienated child and trauma. I don't know of any such work that's being done out there. That being said, I did find with my own child in elementary school, when I was able to do all that meeting and all the discussions with all the administrators and the teachers and so forth, that they did, and it was actually turned out to be very empowering, but it was a short-lived situation. They did have a school psychologist who would go around to all the different elementary schools who worked with the children who are undergoing divorce inside of their families. And they were teaching the children how to stay out of the conflict, how to address a parent who was saying inappropriate things. And I noticed my own son being very empowered, but again, that was only lasted for 2 years. So it's very school district based, and it might be state based, and they're cutting off more and more schools from getting involved in family. More and more schools are getting locked down to how much they can be involved in family systems, right down to books, just so you know that.
You know, the other thing too we want to point out, Cindy, is that Dr. Lynn Steinberg is now in Canada. So Google Dr. Lynn Steinberg, or you can reach out to myself or Cindy for her number.
Yeah,
And,
absolutely. Dr. Lynn Steinberg. I can't say enough about her. And Catherine.
Lynn's amazing, and she is in Canada. And so she might be able to provide some services to your family that you're looking for outside the school. And that might help her in school, and help, help your daughter deal with the trauma of the situations.
Good question here. My plan requires joint decisions for non-emergencies like dental work. My kids need fillings. Surely I cannot take the kids to the dentist for fillings without informing the other parent who insists on non-conventional care. So, yeah, this is a common issue. And what I'm going to say is usually the other parent will be the dominating parent, and they'll be the one going to do all the decisions and making all these decisions and then sending you a bill. Oh, by the way, I got the braces and this is what you're going to pay. And they're doing Invisalign. So, Catherine, I'm going to let you answer that question.
So there's a great line that I would suggest you do. First, you put your notification to the father. The child went to the appointment on such and such date for a dental checkup, and it was determined that there's 2 fillings. If you have any questions, please contact the dentist directly. I will go ahead and schedule an appointment on such and such date. Unless I hear from you otherwise, I assume I can proceed. That's the phrasing you want to use at the bottom of your email. Unless I hear from you otherwise in the next 7 to 10 days, I'll assume that you agree to this. Because what the alienator does is they don't respond.
They ignore you. So then you put the deadline, and then you just got yourself the permission. So okay. The child who has been authorized by the pediatrician to start ADHD medication as suggested by the therapist last year, one parent disagrees and has been reluctant to affirm a diagnosis. They've stalled an intake probably because it would expose their mental health issues and crazy making. This would also stress the child out, as he'd have to be loyal to the false memories and could forego therapy if this parent agrees to allow the pediatrician to prescribe. However, because they've been so against this in the past, I'm having difficulty framing how to ask the child to have a trial medication period before school starts. So in this case, this is the targeted parent who's trying to get the medication for the child. and the child's refusing, but the pediatrician has now, this is crazy making, has deferred it to if the child wants to take it. And I believe this is a 12, 13-year-old child. Is that correct, Jay?
No, it's actually a 9-year-old kid.
Oh, 9-year-old, even
Oh my
younger.
gosh.
He's been diagnosed with ADHD for a year and a half now, and his pediatrician made the diagnosis, and he agreed with it. He agreed with his occupational therapist about it. The pediatrician offered medication if he's having safety issues. Safety issues are coming up, and he's having self-esteem issues because he can't control himself. And he recognizes that he would rather try the medication. His occupational therapist suggested that he try it just to see if it works. And last year, his mom was totally against it. So she wanted to get an extra diagnosis and make sure it was accurate. And then I went through all the hoops to get a therapist lined up and an intake at a neuropsych lined up. And she dropped the ball at intake and doesn't respond to me over it. The kid really wants to try medication at this point, and she pretty much said, "It's up to you, Benny. If you want to do the medication, we can do the medication."
What Jay just said. Yeah, mom says, child, you could do that if you want to do that, while they're being dysregulated, and the child gets the message that they have to regulate that parent, and they know what the right answer is to keep that parent regulated. So it's the front of the hand, back of the hand. So go ahead, Catherine.
I was going to say, then tell since I was interpreting the question that everybody was saying the 9-year-old could decide if he wanted to take the medication and the parents were willing, or one of them was. But I would
it is.
say,
The targeted parent wants the child to get on that because of the behavior, and it's the aligned parent that doesn't want to have the child get on the medication.
right. So I would say to the in an email to the targeted parents, since it appears that the parties are all in agreement that the child is willing and wants to try the medication, let's go forward. Go ahead and set up an appointment on such and such date. Unless I hear from you otherwise in the next 5 to 7 days, I'll assume this is acceptable to you as well. Period. And then during their custody time, they take the child in and get the medication, and the child starts the medication while they're with that parent.
Yeah, by default, you have the permission. If they miss it, that's their problem. So
now what I would do is get in writing the information from the doctor that the child,
he's recommending that the child
is recommending, and it said to the doctor that they're willing to do it, because it's not unusual to go to court with the impression that, a professional is going to say, this is what I told them, this is what they were going to do. And then suddenly there's amnesia. They can't remember. They have so many clients. So get it in writing and then send that email that, since child is in agreement, we're all in agreement that he should try it before the start of school, that we're going to go forward. I'll schedule the appointment. Unless I hear from you otherwise in the next, 5 to 7 days, I would make it a shorter time frame, 5 to 7 days. We'll go forward.
So next question. Their father, this parent has 4 children. They're all young, like 14 is the oldest. Their father suggested an app closed that we all go trick or treating together this year. How do I say no with minimum impact, if that's even possible? And she has 2 very young children under the age of 5 that are, they're neutral, they're not alienated yet. But then she has 2 older children, 14 is the oldest, and one that's a little younger than that are extremely aligned with the father. So any suggestions?
I would say, let's just split up the night. I'll take them earlier in the evening and you take them later in the evening, because the teenagers are going to want to stay out past 8 or 9, and young children are going to be pooped, by 6 or 7. So, and then, with the understanding and add to the email, hey, I'll take them from this time to this time and you can take them. Then you're technically sharing Halloween together. You're just doing it separately.
Yeah, so I hope that's an answer for this parent, because that's a great idea. You take these two, I'll take those two. You know, you this time to that time they have school in the morning, so make sure you have them home by 9 o'clock. Now, to that point, this is a really good example because my therapist gave me this coaching years ago. We would go, my ex only lived 3 miles from me. So it would be like if my children forgot their backpack, I needed to go pick it up. And if they forgot their books at my house, I needed to deliver it. So I was the gopher, you know, always. And I work as well. So it was like, no, you need to bring it. No, you need to pick it up. You know, that was how it went. And we would get into these battles. And I was living at that time, it was new in my divorce, and I was living into, well, that's not okay, and I'm okay to do it sometimes, but no, I can't do it all the time. And we were starting to get that conflict. So my therapist said to me, why don't you just take all the power out of that conversation? Who's picking them up? Who's dropping them off? And we didn't have that in a court order either. So she said, why don't you next time when you have any of these issues about who's driving where or what, just simply call and say, oh, just check it in. Do you want me to pick it up or you want to drop it off? Or you want to pick them up, or you want to drop them off. And she said, you take away all power. And because for them, it's whatever you don't want, they want to take from you, you know. And my ex was flabbergasted when I did that. And it was so true. And the first time I did that, he's like, what? What? And I said, it doesn't matter, you know, what do you want? You want to pick him up or you want me to drop him off? Well, I don't know. What do you want to do? I said, doesn't matter. Like I said, would you just tell me what you would like me to do? He did not know how to answer that question. And I took away all of his narcissistic supply power. So keep that in mind. That's the personalities we're dealing with.
Right, okay. Because then you're actually, without realizing it, you're giving the alienator, hey, they're picking up or dropping off. You're not picking up and dropping off. They're going to have to choose one or the other. But you do it in a way that doesn't give the appearance that you've given up anything or they've lost anything.
Okay, so that parent regarding the Halloween, he wants to go together. Well, he can't have what he wants. So you have to just, depending on who has custody, and if he has custody, say, have fun. If you don't want to take them, I'll take them. But no, we can't go together. And something that I want to invite you to consider is, you know, we're separated for a reason. It's my day, but if you really are, you know, committed that you want to have them, feel free. You can take them. And now he, just like how I said, you want me to pick them up or take them, he's not going to know what to say because the point is to torture you.
And I think the point too that we want to make, Cindy, in all these conversations, like I said, we are identifying genders, is the ISNAF and myself, we feel very strong that men and women are both victims of alienation. And I don't really care. I represent just as many mothers as I do fathers and just as many fathers as I do mothers. But alienation is just, you know, it's abuse.
To your point, there's a new group out there it's the Alliance of Alienated Mothers, I think. And it's a brand new group started by a therapist. It's here in California. And I've had several parents send me that information. I'm thinking about joining this. Maybe you want to join that. So, and there's also a Fathers Coalition who's now National Families Rights, whatever. So here's what I want to invite you all to consider. Great to get all the support you can. If it's informative, you should absolutely go for it. Parental alienation, to what Catherine just said, is not gender specific. There are no studies or research, or there's no clinical research that shows it's gender specific. So yes, you can get into fathers' rights groups and deal with some of the issues that might be specific to fathers. You can get into a mother's rights group and deal with some of the issues that are very specific to mothers and what we might be dealing with. But it is not a gender issue. It is a cluster B personality issue. And cluster Bs are in the realm of both male and female. So I just kind of say when we start fighting genders, we're not doing ourselves favors. We're really not. So if there's some special support you getting that support to your gender, go for it. But I really invite you all to not get involved in it's all mothers and it's all fathers. And no, that will get us absolutely nowhere. Now we divide and we go nowhere. And in fact, it's been a fact for multiple years with the level of funding and lobbying they do. The National Now Organization of Women has been a huge lobbyist against the fact that parental alienation exists, and it has set us back multiple. And not only that, now it's setting us back in other areas of life that I'm not going to bring up. But if it's you need specific, you need to hear from mothers and you need to hear from fathers, do the work. But I want to invite you, be mindful not to say it's them and it's them. We're not divided. We are all together. So thank you for bringing that up, Catherine. So with that, I want to thank you all for joining us. We've covered all of our questions. Go out, be powerful because you have power. Do not allow anybody else to take your power from you. And there's always the workaround, and that's the really eloquence of the parallel parenting, is that it lets you see, yeah, we don't have to go along to get along, and we don't have to give them all the power, and we can have our own stuff, and we can do our own things, and have our own rules, and have our own, uniforms and clothing, and all of those little things. So with that, I'm going to say thank you, Catherine. We sincerely appreciate your presentations, and we'll look forward to the next one. And you always come up with a new topic. So good night to everyone. Go out, be powerful, and we'll see you at our next meeting. And all.